Good afternoon, everyone. If you could, go ahead and take your seat. I'm Bo Chilton. I'm the CEO of Impact Community Action. Let me welcome you to Impact, where our mission is to fight poverty by providing hope-inspiring help and real opportunities for self-sufficiency. I want to thank everyone who came out tonight to hear a very important panel discussion of our judges. Often a race that goes below the radar in our community, but such a critically important office, and we want to be well informed and hear from the judges and their thoughts and opinions. And very happy to have some young people here from our Boss Up program, where they're learning to be entrepreneurs, and they may have some questions that they need to ask as well. Really want to thank the League of Women Voters for your partnership. We have been partners for at least the last 3 years and working on voter registration, education, and as we talked about, there's still more work to do to mobilize our community and keep them informed, but we'll continue that work, and we really appreciate your partnership. Thank you to all of the judges who have come out. I know that it is time-consuming when you have to run for re-election, but you are out here in the community, and that's important. That is noted, and we appreciate your time. So with that, I want to say thank you to Keith and Lauren for being our point people and bringing this partnership with the League of Women Voters together. Appreciate all of the staff who have contributed. Really love seeing the young people here that came and introduced themselves to all of us. That is a good practice to have. And thank you all for being here. And with that, I'm going to turn it over to Elizabeth.
Hello, I'm Elizabeth Breezer. I am the Operations Manager with the League of Women Voters. We often put on various candidate forums, candidate meet and greets throughout Franklin County so that voters have a better idea of who candidates are and what races will be on their election. So just a little bit of information about this upcoming election. Make sure you have a voting plan for the November 5th election. Early voting started yesterday, and we had 4,000 voters in Franklin County that went out to the Early Vote Center on Morse Road and voted yesterday. So that location is open now through November 3rd, various hours. So please go out and vote early if you'd like to. You can also vote absentee by mail if you're interested in doing that. We have application forms for that here today. You can fill one of those out and request a mail-in ballot. Or make sure you look up your polling location where you will go and vote on November 5th. So the candidates sitting before you are all running unopposed for their judicial position, which is for the Franklin County Court of Common Pleas. So this is not an official candidate debate because they are not running against each other. And although the candidates are running unopposed, this is an important opportunity for us to learn about what judges do, how they affect our community, and what each of these judges brings to the table in terms of their experience in judicial philosophy. So each judge is going to have a few minutes to introduce themselves, and then our moderator, the cleaner, will be asking questions of each of the candidates. A few of the questions are pre-written, and there's also an opportunity for audience members to ask questions. If you'd like to ask questions, we have these little slips of paper. We ask that you write your question out, hand it to me, like the best person, hand it to me. I will review it, just make sure that the question is appropriate for all of the candidates and that it's not duplicative. Another thing to keep in mind is that with judicial candidates, there are only certain questions that they are able to answer in their official capacity. So on this little slip of paper, it gives you the disclaimer, but I want to go over it here. The Judicial Code of Ethics, under the Judicial Code of Ethics, judicial candidates can only answer questions about their knowledge, judicial philosophy, effectiveness, character, and experience. Judicial candidates cannot answer personal opinion questions about issues, and an example of that would be their view on abortion or the death penalty. Each question will be asked of all candidates, and we will not be keeping time as this is not a typical candidate forum only. And now I'll turn this over to Keith Ware, who's the Director of Community Engagement and Advancement and Impact, to direct the opening statements and ask questions.
Thank you, everyone. Appreciate you guys for being here. Take the time out of your busy schedule. We really appreciate it. So we want to get started because we don't want to waste anyone's time. And so I want to start off on this day and just talk about, just give an overview of you and who you are.
Good evening, everyone. My name is Jaiza and I am a judge in the Franklin County Court of Common Pleas General Division, which is the adult felony court, and we also hear lawsuits that are $15,000 and above. A little bit about me: I grew up here in Columbus, Ohio. Once I graduated from high school, I went to college in Washington, D.C., and said that I was never moving back to Columbus, but little did I know that there was a greater plan for my life. I knew since I was 8 years old that I wanted to be an attorney, and I attended the Ohio State University Moritz College of Law. I then was an assistant city attorney for the city of Columbus, and I did public nuisance work. And the best way that I would describe that to people is I would say, if there's something in your neighborhood that gets on your nerves, I would figure out if there's a legal way to address it. And so that would be anything from if your neighbor's dog is barking all night, all the way to if there was a corner store in your community that would sell alcohol to minors or that would sell drug paraphernalia. We also worked on hotels and motels that would allow for any type of criminal activity. I did that for 4 years. One of my most well-known cases is Motel 1, for anyone who is a longtime resident of Columbus, getting that motel shut down, and now it is a Bank of America. So really the work that I did was to try to turn around neighborhoods using the legal system. I was then appointed to and later elected to Columbus City Council, which is where I kind of began my political career. I did that for 4 years, and I was also of counsel at a law firm called Eastman & Smith, where I continued to do civil litigation, primarily in public nuisance work and also environmental work as well. I was then encouraged by one of my mentors, who was a former Columbus City attorney, Richard C. Pfeiffer Jr., to run for judge. And so after a conversation with him and just really thinking about my passion for the law and my love for our community, I decided to run for judge. And I ran the first time in 2018, and I was successful and started my first term in 2019. And I am finishing up. We have 6-year terms, and I am running for re-election. So thank you all for your time this evening. Thank you to Impact for the work that you all do in the community, and thank you for the League of Women Voters. I think this is probably my 3rd forum that I've been a part of, so I appreciate you bringing people together to learn more about the work that we do.
Good evening, everyone. I'm Judge Karen Held-Phipps. I sit on the same bench, so I'm in Common Pleas General Division as well. So, and Jaiza and I ran together last time, so we're on this, actually, Judge Kim Brown ran with us as well. So the 3 of us are all in the same court. So I'll get to who I am. I live right on the other end of Southwood, down closer to High. I was gonna walk, and then I got lazy, so I drove. But I took a non-traditional route through the law. I was young. I decided to get married. I had kids very young. I ended up single with 2 children at 28 with only 2 years of my education in. So I decided, well, I better get some learning in. And so I went back to school when my kids started school. I went full-time and worked on the weekends, finished up my undergrad at Capital, and then I went to Capital University day program and continued to work nights and weekends to support the kids. And my kids are grown now. My son is 35, about to be 35 this month, and he is an entomologist, so he has a PhD in entomology, which is a bug doctor, for those of you who don't know that. But he does research, and my daughter teaches science in Reynoldsburg. I went out on my own quickly after graduating from law school. I had a business finance degree. I thought I was going to be in business finance because that's what I loved. But business finance law is not a happy place with unhappy people, and I wasn't really doing any good for anyone. And so I went out on my own, and I quickly turned and started doing criminal defense, and I did criminal defense for 15 years, practicing in the court that I now sit on. And I can speak for everyone here tonight. We all care about our community. where you'll see us, you'll see me walking my dog, say hi. But also just we come out because people need to understand that part of the reason so many people are inspired to follow the law when they're young is you see inequity, you see unfairness. And in my household, my mom and dad were good Catholic people. I have 10 sisters and 5 brothers. And I was at the younger end, and we used to have to stand in line with our report cards and hand them to dad, and dad would read them and sign them and talk about your grades. And I remember being one of the younger ones, standing there going, the boys sure are hearing a different thing than the girls are hearing. Boy, you got a C. Good job, son. You brought that grade up. Girls, you got an A-. What were you doing in class? And at a very young age, I had a perception of I wanted a job that made the world fair. And in my mind, being a judge, that's what your job is to make the world fair. And so that is what inspired me. I didn't get there the normal path, but I'm here now, and I'm really happy to be serving our community.
Good evening, everyone. I'm Kim Brown, and again, we're all on the same court, or soon to be on the same court. I've been on the court, I'm finishing my 12th year, so I'm running for re-election for my 3rd term. What I love about these kind of forums is getting to listen to how other people got to be a judge. I mean, there are so many different paths that you can take and become a judge, and I think that's great, and I think it's really important for younger people to understand that too. There is no one way to become a judge. I grew up in Belmont County in Eastern Ohio. My dad was a coal miner and a truck driver. My mom retired as a manager of a Spencer gift store back there. I came here for school. I went to Otterbein for my undergrad, Capital for law school. I knew early on that I wanted to go to college and to law school. I joined the United States Naval Reserve on my 17th birthday as a way to help pay for school. In '91, I was reactivated, put on active duty in support of Desert Storm. So I served for 6 months back then. It was a total 8-year enlistment and I was enlisted. I was not an officer. I did a lot of saluting. Nobody saluted me. So I worked at a law firm in Columbus. Back then it was called Bricker and Eckler. It is now called Bricker Graydon. They merged with another firm about a year ago. I did civil litigation. The firm had a lot of public entity clients who represented a lot of school districts, counties, cities, townships. So I did a lot of work that was related to representing those types of entities. I did construction litigation, so when school districts were building new schools, we were involved in not only helping them with their contracts, but then if there was litigation in that process, we represented them. I also did some eminent domain work. That's where you take property for a public purpose. In a lot of those school projects, we had to do that, whether it was for ball fields or for the roads to get to the new schools that were being built. I also did some other different types of litigation, and I was there it was about 17 years, and I was interested in becoming a judge, but frankly was scared to death of running for public office. And a couple of the folks that I worked with at the firm had made that step to becoming a judge. One of them in particular I stayed in contact with, and when a seat became open in our court, she assisted me in, how do you run a campaign? How do you get the nomination? How do you do all those things? So I was very fortunate to have a friend that assisted me, and I was also very fortunate to be elected the first time that I ran, and I enjoy what I do. As Judge Held-Phipps said, we're all very passionate about what we do, and every day is a new challenge at the court, and I really enjoy that. But I appreciate all of you being here, and I look forward to your questions.
Thank you, and first, thanks for all of you being here tonight. It's really good to see you. Thanks to the League of Women Voters and Impact for providing this wonderful facility for us to do this tonight. My name is Rich Brown. I'm the only one up here who is not currently a judge. What I am at this point is a state representative. I've been a state representative for 7.5 years. I represent District 5, which is Southeast Franklin County, Reynoldsburg, Opetz, Lockport, Groveport, and Canal Winchester, which is where I live, and I've lived there for 28 years. But I'm a lawyer too. I've been a lawyer 42 years. I grew up in a little town on the river, Ohio River, called Ironton, small town. My parents were blue collar folks. My dad didn't go to college. My mom was a church secretary. They stressed education. Education, they said, was very important. I had one older brother. He became a doctor, and I became a lawyer. Went to University of Cincinnati undergrad and came up to Columbus to go to High State Law School. And got out of law school in 1981, and I've been a lawyer in Columbus, Oregon, and Winchester ever since. When I first started, I was with a couple of different law firms. I represented a lot of big companies, banks, insurance companies, Fortune 500 companies, and I did that for quite a few years. I'm a civil litigator primarily. I tried lawsuits all over the state of Ohio, usually defending either individuals or entities that have been sued. And that was good. I enjoyed it, but there came a time where I felt like it was time for me to start representing people and not big companies. So in 2010, I decided to leave the law firm I was a partner in and hang my shingle in Canal Winchester, open a small practice and sole practice and see what happened. So I started doing that and representing individuals, small businesses, but mainly individuals, and usually on the other side of the cases from where I had been before. And I found it much more rewarding, trying to do things to help individuals, help people, help them with their legal problems, legal issues. And it was very rewarding. About 2017, one of my friends, who was a lawyer and also happened to be a state rep, told me about an opportunity. The state rep in the district where I lived had resigned, and the position was open. And he asked me if I would be interested in running for the seat or applying for it. And at first I didn't want to because I didn't really ever think I would be an elected official. But I thought about it and I thought, well, why not? So I'll apply. If I get it, I get it. If I don't, I'll just keep being a lawyer. So I applied, and the Franklin County Democratic Caucus of the Ohio House and the Ohio House Democratic Caucus chose me for the position. I did a year and a half of the appointment. Then I was elected for the first time to my rep seat in 18, re-elected in 20, re-elected again in 22. As a state rep, you have to run every 2 years. So I've been elected, a successful elected official 3 times. I've been in the State House 7.5 years. While I was in the State House, I was the Assistant Minority Whip, which is one of the 4 elected leadership positions, and I was a ranking member on important committees like government oversight, civil justice, and criminal justice. So when I was in the State House, I focused on legal matters and legal issues that were relevant to producing legislation about those matters. Then the opportunity arose for me to consider running for the Common Pleas Court of Franklin County. I had always had an interest in being a judge, and my time as a state rep was running out. I wanted to continue public service. So I thought that why not combine my desire to be a public servant with my legal background and my legal experience in education and run for a position on the Common Pleas bench. I had a contested primary in March. I won that by 10 points. And so now I'm the person running on the Democratic side of the ticket. There is no Republican opponent, so I'm running unopposed. So I hope that I win. I think I will. I should be. As long as my wife votes for me and I vote for myself, I think I'll be all right. So, but I look forward to being on the bench. You know, what I think a judge should be is very simple: fair, impartial, show respect not only for the litigants and their families, but for the attorneys in the court, and also respect for the rule of law. Also be impartial and be compassionate. Those are things that I think every judge strives to do, and what I will strive to do once I take my seat on the bench beginning on January 7th. So thank you again for being here. It's my pleasure to be here, and we look forward to some questions.
Awesome. Thank you. So piggyback off of what you just said in terms of fairness, my first question, and we're going to kind of mix it up a little bit. We're going to start on this end, then we're going to start on this end, so that everybody has an opportunity. So first, I know you just got finished talking, but I just wanted to dovetail off of what you just said. How would you ensure fairness in your court?
Well, you treat people like people. They are individuals. They're not just a number. They're not just a defendant or plaintiff. They are a person. They are there for a specific reason. Usually it's a particular case, whether it's civil or criminal. That's the most important thing to them at that moment in time. And you have to treat them with respect and realize that this is a really important thing. They're here. They're either bringing a lawsuit, defending a lawsuit, or they've been accused of a crime and they're defending themselves against the state's accusation. And they have every right to be heard. They have a right to be judged by either the judge and or the jury impartially without bias. It doesn't matter who they are, what they look like, where they come from, how much money they make. They deserve the exact same opportunity as anyone else sitting in that seat for that particular case.
Thank you.
Oh, sure. Yeah, I mean, and I agree with what Rich just said. And I think that what we have to do as judges, again, we're supposed to be fair. We're supposed to be impartial, not biased. And we just have to remind ourselves, I mean, especially as you do this longer and longer, everybody is different. Every case is different. There are no preconceived notions or ideas when a case comes before you or a defendant comes before you in a criminal case, or two parties or more come before you in a civil case. So you take every case and you do the best that you can to make sure that the process works for those parties, and that it's fair.
Ditto, but I will add, one of the things of making sure that you treat everyone fairly and equally is to understand the difference between equity and equality. It's two completely different things. And on occasion, it's usually in a criminal case, when the state stands up to talk about what they think the appropriate sentence is, they say something like, well, with all things being equal, I stop them right there. I said, nothing is ever equal. Every human being has gone through a different experience, and you can't say that. We have to treat everyone as an individual. And not only if the lawyers are doing a great job, you get all the information you need. Sometimes the lawyers aren't doing the best job, and you have to ask for more information. And that's something you learn the longer you're on the bench, is sometimes, you could add a little to that, and you just politely encourage people to share more or to go get more information so that you can make the right decision.
I agree with what my fellow judges and soon-to-be judge has said. So I would like to do some audience engagement to kind of answer it a different way.
Oh, no doubt.
That's okay? Okay, so we have some young people here. Shania, I remember your name because you told me your name, okay?
Uh-oh.
Young man, what's your name besides Shania? Jamarion? Okay, so Shania told me that you stole her $5 bill and I said that you're guilty. Is that fair?
Who are you asking?
I'm asking Jamarion. And why isn't it fair if I just say that you're guilty? She has no proof, and what else? Yes. So, as judges, those are things that we are not supposed to do. So we shouldn't just hear one side of the story and say that this person is guilty, or hear one side of the story and say this person is liable if it's a civil case. And so we have to look at the evidence that's presented, and if there's no evidence, then it's hard to prove what the other person is saying. And also, we can't make assumptions, and we have to give everybody the opportunity to share their side of the story and to share what they believe are the facts before we take that into consideration as either a judge, or if it's a jury trial, making sure that the attorneys are following all the rules so the jury has everything that they need in order to make a fair decision.
Awesome. Thank you. All right, next question. This is an audience question. What are bonds and what do you think of?
So a bond is what happens when someone is arrested and they are arraigned. So if you are charged with a crime, or we would say indicted, then the police will arrest you, but sometimes it can be a situation where you come in on what's called a summons, so you're not necessarily arrested, you're just required to appear in person. And then the judge or the magistrate will give you what is called a bond, and that is not always a monetary bond. It can be a recognizance, which means that you get to leave and you don't have to pay anything that day. But there's something that's called like a monetary bond, and it could be as low as $1 if a judge or magistrate did that, up to an amount that is as high as the judge may deem appropriate. And the things that we take into consideration when considering bond, one, are public safety, are also whether or not that person is going to come back to court. So if someone has missed court before, we take that into consideration, their ties to the community, and all of those things. So that is what bond is, and the question is, what do I think about bond? So right now, that is the law, and so as a judge, I'm required to follow the law, and when I am imposing bonds, I take into consideration the law in order to set what I believe is a fair bond.
Thank you. This is what you think about, what do you think about?
I feel like again, we're in a situation where one side presents information. Usually the prosecutor will read into the record the prior history of the defendant and the person who's accused, and so whoever is hearing that information must make a decision. Now, often as judges, even though you get bond once at arraignment, bond can be changed. So your case gets assigned to a judge, then the attorneys can go before the judge and ask for bond to be changed. Sometimes the state is asking for a higher bond because something happened, like say it's a domestic violence situation and he's harassing the woman. So sometimes the state would ask for the bond to be revoked so that they were in jail to help her be more safe. Or they'll come before you and say, my client's bond is $50,000. He can't get out of jail. She can't get out of jail. Would you consider reducing it? And we could possibly reduce it. So my thoughts on bond are, it used to be you'd get 1 or 2 opportunities to discuss bond. COVID taught us all that you can't just let people sit in jail while the wheels of justice are turning in this crisis. So you just have to address it as many times as you have to address it. And I sometimes address it every time someone is scheduled for court, because if they've been sitting for 1 month in jail because they can't post a bond, but 2 months later, someone in their family's gotten them a job or gotten them a secure housing if they were homeless, or we can get them resources that'll keep them from living on the street while the case is pending, we can lower the bond and let them out.
Yeah, I guess, and I would just add, there are conditions that we can place with the bonds on people. If it's a situation where somebody should have a lower bond, or if they should have what Judge Page talked about, the recognizance bond, where basically you're released on your own recognizance and you only have to pay if you don't show up. We can add conditions onto that to protect alleged victims or protect the community. We can do things like stay away orders. If it's like a domestic violence, felonious assault, something like that, we can put an order in place where the defendant has to stay away from the alleged victim. We have a very robust GPS monitoring system now. So we can do house arrest where somebody has an ankle monitor, they're not allowed to leave their house unless there are certain things that we permit them to do, like come to court, medical, spiritual, those kind of things. But we can also do what is just more of a GPS monitoring where they can leave their house, but there are zones that they're not allowed to go to. So if you have an alleged victim, you know where they live, you know where they work. The defendant can have that ankle monitor, they can be out and about, they just can't go to those locations where the alleged victim might be. So we have some flexibility as far as the types of conditions that we can set with those bonds. And I think that's very important, and I think, the three of us that are here, we all do that. I think it's important that people understand that there's more than just a dollar amount that goes into bond. There are these other conditions that we can set as well. And it's very important that, we as judges consider those options and make those available where it's appropriate with defendants.
Since I'm not a judge yet, I haven't set any bond for anybody at any level, and I'll learn that. But I will say this: you have to look at every case on its own merits. You have to look at every individual and make an assessment as to what is appropriate in this particular case. And it's not one size fits all. And I think the judges here have explained it in detail and very well, and so I won't add any more. Thank you.
I appreciate it. This question is kind of a two-part question, but it can be answered kind of together. Is there a code of ethics for Ohio judges, and how is it enforced?
Or did you want to?
I'll just be real brief. Yes, there is a code of ethics for judges, and it should be enforced all the time. And it is enforced by people reporting ethical violations, and then the violation is directed to the appropriate officials who look into whether or not a judge has committed a violation of the Judicial Ethics Code. And so there's a whole process and procedure. It's pretty complicated and complex, but it's there. And yes, judges are all very aware of it. I mean, we're aware of it. There's certain things, even as a candidate, you can't say, and we won't, even if we wanted to. And so we're all very cognizant of that. It's very important because all of us, I know all of these judges here, I know them. They're all good, very good judges, and they all abide by the code of ethics very stringently, as they all should. And I intend to do the same.
Yes, and again, we do have an Ohio Judicial Code of Conduct. Judges are required to comply with that. There is mandatory training on that. We all have, as lawyers, we're required to take so much continuing legal education every 2-year period. As judges, that's elevated. There are more hours that we have to take, and part of that is judicial conduct. And the focus of that is how you comply with the rules of judicial conduct. And the entity that actually enforces those is called the Ohio Disciplinary Council. They're part of the Ohio Supreme Court, and you can go out to their website. They tell you how that process works, how you would file a complaint against a judge if you feel that they're doing something that is a violation of the code, and how that process works. So we're all very aware of that. Also, they will also answer questions. If you just want to call them and ask them, if a judge is doing this, is this something that might be a violation? That they talk to the public, they talk to us. If we have concerns about something that's going on in a case that we have. So you can contact them and ask them what they think as far as, whether judges are taking actions that might be in violation of the code. Oh, sorry, let's do it this way.
I can just add a little bit. A lot of the courses we take throughout the year, because we're required to take more classes, more continuing legal education than the normal attorney does, helps us deal with specific issues, because there are just every day there's new issues that come up before a judge, and we take a lot and we learn a lot about the pressure we're under and how to better control your temper, because judicial, you need to act a certain way, and losing your temper and bringing your personal life into the courtroom isn't allowed. And so I do like the fact that we can call. There have been times where I have called and said, this just doesn't seem right, and how is it best for me to handle this? And they'll give me ethical advice, and I hope everybody does that, because one, you never stop learning, and two, there's so much new stuff that comes before us every day. So we all adhere to the code of conduct, and I believe that it's a good checks and balances.
And the last thing that I would add, in addition to the code of ethics that we have, we're also required to file annual financial disclosures. And so I know that has just generally been a big topic on more of a national level. So, and this is required for all electeds in the state of Ohio, depending on the level that you are in, and whether executive, legislative, or judicial kind of determines what you are required to disclose, and also really your salary. but we have to list any creditors that we have, any debtors that we have. We also have to share, like if we have a savings account, even if you only made $1 the whole year, like my savings account. And so this is all information that we disclose every single year. It is a public record. I believe ours is held with the Supreme Court, but the Ohio Ethics Commission is the body that handles all of the other disclosures for the other offices.
Awesome, thank you, thank you. Next question, how can you make common pleas more efficient? The court more efficient?
That's a great question, and I think it's something that we all think about every day. So at this point, I have a little over 700 cases, and so that is a mix of civil cases and criminal cases. As we see an increase in criminal offenses in our community, we see an increase in the amount of cases that we have that are being filed. And so what I try to do is to, one, to the best ability that I can, comply with the guidelines that we have from the Ohio Supreme Court that give us a certain period in which to dispose of cases. But that becomes difficult, particularly in criminal cases. If you have a murder case, you cannot get that resolved likely in 270 days. And so what we just try to do is make sure like the cases are moving. When we are giving continuances, they're typically for a shorter period of time so that the defendant always knows that their matter is coming before the judge, and really just trying to make sure on the civil side we're getting through motions as quickly as possible and issuing decisions as quickly as we can.
And just so the general public understands, your caseload is mostly civil, but you spend like a quarter to 3/4 mostly civil and less criminal, but you spend much more time in the courtroom on your criminal matters. So typically we spend the morning docket on our criminal matters, and sometimes that'll go into the afternoon, and then in the afternoon we work on our civil docket, and that's mainly because of the fact that civil is a lot more motions practice. They come to court less, and their cases take a little longer because they have the discovery process that is different. So how to make your, as a whole, I don't influence her docket. I don't influence her docket. I am in control of my docket. So as a whole, we are all working, I hope. I also don't, I'm not anybody else's keeper. So I know that I've worked very hard. When I took over my docket, it was a retiring judge who was doing a great job, but his pace had slowed down considerably. And so I had 200, 250 more cases on my docket every day than I do now, because I try cases, that's what I do. So being at work and really engaging and monitoring, like Judge Page said, you have to pay attention to the criminal dockets, because sometimes continuances they'll ask for 60 days when they really should be coming back in 30. And so we daily each have our own method to kind of stay on top of things and make sure people have their day in court when they need their day in court.
So I would start with the court as a whole. For example, we try to use technology the best we can to make things more efficient. We have a very good electronic filing system that we continue to improve upon. So parties, can file online. They don't have to come to the courthouse anymore. We use, and probably more as a result of COVID, we use Zoom a lot more, especially with our civil cases. That makes it more efficient for the attorneys. They don't have to get in their car, come downtown, try to find parking, then come into the courthouse, then do that reverse. We can do it on Zoom. It takes maybe 15 minutes to a half hour out of their day instead of a couple hours. So we're constantly looking at ways to use technology to become more efficient as a court. As far as our individual dockets, it's really a function of, for me, having a good team around me. We each have a bailiff. Generally, they help us with our criminal docket. We each have a staff attorney. They're generally focused on helping us with our civil docket. We have secretaries. We have magistrates. So it's, as you become a judge, as you get more experience, it's using those folks to make your docket as efficient as possible. For example, I have a couple of really complex civil cases right now where we have 100+ parties in each case. I've gotten my magistrate involved in those. She does status conferences with them on discovery issues, everything else, to keep their case moving. Because if they had to wait to talk to me on that kind of regular, it just wouldn't work out, because I'm in trial, I'm dealing with my criminal docket. So it's just finding ways for our individual dockets, using our team that we work with to become more efficient.
And all of what you just heard is better than what I'm gonna say, because they've done it, I haven't done it yet. So, you know, you have to develop your method, what works best for you as a judge, and try to be efficient the best way you can. Technology is important, relying on a team is important. Judges do have a team. You try to assemble a good team and use them in a way that helps you be more efficient. I will say one thing though that hasn't come up. Franklin County Common Pleas judges have a lot of cases. There are 17 general division judges in Franklin County. Franklin County is the largest county, most populous in the state of Ohio. Cuyahoga County is number 2 in population. They have 34 general division judges. They have twice as many judges as we do. So at some point, I'd like to see Franklin County get a few more Common Pleas Court judges to help alleviate some of the caseload. But at this point, the reality is we have 17, and you have to work hard as a judge, keep on top of the docket, and use your team wisely and efficiently.
Cool, thank you, that was awesome. All right, so this question, a little different. As judges, do or can you use social determinants of health to play a role in individual cases? So, in terms of if someone was struggling with something, I mean, in terms of you making your decisions, and I'm assuming that's what it is, do you add that into your decision making?
So one thing that we get when we are sentencing defendants, we can, not all the time, is what's called a pre-sentence investigation. And so that pre-sentence investigation will tell you everything about the individual that is standing before us. And of course, a lot of this is self-reporting, so the more that the individual shares with the interviewer, the more information we will have. But this tells us about their history growing up. What did their parents do? How many siblings do they have? Do they have anybody in their family who has prior criminal history? So we learn a little bit about the environment that they come from. It then has a section for mental health. It has a section for substance use. It lets us know whether or not they were ever in the military. It tells us about their education level. We can find out if they graduated from high school or not. Did they have an IEP while they were in school? And so all of that information we are able to use and take that into consideration when we are imposing a sentence. And typically our options are community control, which is a probation, or prison. And so we have all of that before us. Again, this is not every time, but a majority of the time. So we are able to take into consideration, and also they ask them about their health. So they ask them, do you have any, like, do you have diabetes? Do you have any other health issue that the court should take into consideration? So we have this wonderful packet of information, I call it, that helps us to make sure we are considering everything about this person and imposing an appropriate sentence.
And along those lines, I also, in cases where I feel it would be helpful, I encourage counsel to write a sentencing memorandum, which they go out and gather even more information than the PSI, and then they apply the facts that they can provide to the court to the sentencing law. And so it's usually pretty long. I do allow letters to be submitted to me from family members or coworkers. I allow those to be private and not to be part of the public record, because if a mom has something they want to say about their child, or if a whoever, aunt, grandma, dad want to say something, they may not want it in the public, but they may want the judge to know. For example, I had a defendant who had been sexually abused, and he was a drug addict now. And he didn't tell the PSI writer, he didn't tell his attorney, but I got a letter from a family member that told me that, and that that weighed heavily on my decision to find the right program for him to go into so that hopefully he could get the counseling he needed. I have family members who are dual diagnosis, which means you're addicted to something, but you also have mental health issues. So that is I've learned to identify that very quickly because they need special treatment. Because sometimes using drugs makes the voices go away. And if I can make the voices stop, then I'm in a better place. Well, they need a special counselor to help them get on the right meds and to do those things. So that's the reason I allow family letters and victim letters to be completely private, because they don't need to be in the public eye if I'm just using it to determine how to help someone best.
I would just add that on the criminal side, I think that probably the majority of cases that we see, somebody has a mental health problem or a substance abuse problem or both. So we're faced with those kinds of situations all the time when we're sentencing people. And having that information is important for us. It could be the difference between probation and prison, or if they're getting probation, the type of caseload that they're put on when they're on probation. Is we have a mental health caseload. We have a chemical dependency caseload for our substance abuse folks. So that is all really important information that we take into consideration, especially when we're sentencing people.
And I would just add that the answer to the question is yes. You do take into consideration these things, and it does make a difference. Judges have to follow, there are certain sentencing guidelines that are statutory, depending on the crime alleged and if it's proven. And so judges have to follow that within certain parameters, but they do have some discretion on most cases to do or not do certain things, and they do look at all these issues as the judges have explained.
Awesome, thank you. Last question of the night. So it was 2 questions, but I had to pick, so whoever wrote the second one's not mad. So, all right, here we go. What community services or rehabilitation services are available as alternatives to incarceration?
You want me to go? I'm sure that I will miss some, but we do. We have a lot of programming available, and primarily we use it with our probationers. First, we have something called the community-based correctional facility. So that is like a last step before you're going to send someone to prison. It is a lockdown facility, but it is focused on programming. They can get substance abuse treatment. There is now sex offender treatment at the CBCF. They learn life skills. There's like anger management. There's all types of programming at that facility. And it's usually a 4 to 6 month program. We have those facilities for men and women that we use. Then we have Alvis House, who's out there that helps with substance abuse issues, that kind of thing. I'm going to just pat it because I know I'm not going to hit them all, and I don't want to take them all from anybody. But we do have a lot. There are a lot of programs available that we use, especially with our probationers.
Well, what's really important about the new structure in our probation department is they know everything that's out there. And part of the good thing that at the end of CBCF, whether you stay for 4 or 6 months, when you get out, if you're homeless or you need resources, probation comes and meets with you, mental health will come meet with you, they will help you get to the YMCA, or if you need a temporary housing, if you need a job, you can get your GED there. So our probation department is a wonderful resource because there are lots of different programs, but our goal is to have probation help us find the right one so people can be successful. And I tell my people when I put them on probation, listen, this is your chance to do the right thing. If you stumble, that's one thing. If you go out and commit more crime, then I have to protect the public and I don't have any choice. So I'm not expecting you to be perfect, but I'm expecting you to try and put in as much effort as everybody around you is to try and help you. And so one of the things I really like about our probation department is I can call the probation officer and say, hey, I have this gentleman, he's homeless, he's mentally ill, every time he gets back on the street, he stops taking his medication. Elvis isn't appropriate for him, what can we do? And right away, Redmond House, it's for mentally ill people, they connect you with doctors, they really create a smaller environment because of the people who don't do well in big groups. There's just a lot out there, and I'll be honest, I rely on my probation department to find them, other than when I go out in the community and I learn just about something new. But even rehabs, you have to get people, they can't be going to the rehab on the same street they were using drugs. They have to be further away. They have to be away from their old crowd and that kind of thing. And so there's just so much to think about that I rely on our probation department.
I do as well, and I would just add that we have a lot of community partners that can provide a plethora of services depending on what the individual needs. So that can be outpatient, that can be inpatient, intensive inpatient. Impact is an example, a fair chance employer, as I learned today. So hiring those that we put on probation so that they can be employed. So I would say in our community, we have a lot of different partners who are working together to try to make sure that individuals are successful. It's just finding those. And we also, two of our colleagues have what are called specialty dockets. And so one is for mental health, that's the RISE court. And then for substance use, it's called TIES. And so those are for individuals that all of us can refer someone to that docket. They then become a part of, I guess, the specialty docket. And it's really more intense services that are provided for them to either address their mental health needs or their substance use disorder.
Awesome, thank you. Can we please give them a round of applause? Thank you for coming out tonight. Thank you for answering the questions and just being committed to what the community needs. And so we want to thank you and we appreciate your time. Have a good night, everybody.
Thank you, everyone,
Thank you.
for being here.
Thank you, it was very nice to meet you.
Very nice to meet you.
So before you guys leave, we gotta take pictures.
Oh,
Ain't
okay.
nobody get out here without pictures.
That's fine. Without the sun blinding us.
And the sun is gone now, so we can actually look at it.